Hey guys, welcome. Welcome to the show tonight. How's everything look? Everything looks good. Running a little bit late, but better late than never. And we got some stuff to talk about. So we're going to get rolling here. As soon as we check everything. Tonight we're just going to stream on YouTube tonight. So I think you get more people when I just stream on YouTube. Well, actually, it's YouTube and Zoom, Zoom Tube. That's what we're streaming. That's what we're streaming on tonight. So everything looks great. Well, let's just get started. Welcome to Advocates for Justice Paralegal Service. We have the tools, and you do the work. So tonight we're going to talk about a couple of different things. We're going to talk about blocking the eviction process, the illegal eviction process, and we're going to cover again the change of venue motion and talk a little bit about it. And I lowered the price on a change of venue motion to $25. So anybody struggling that's broke should be able to come up with $25 to use that change of venue motion to remove that case from state court over to federal court. But before we get started on all of that, I want you guys to click the bell, click something and ring stuff and, do all that. Okay. I need you guys to click those annoying ads that pop up so YouTube will pay me. And make sure that you subscribe to the channel. Make sure you hit the like button and that bell, you got to ring that bell so you get notifications when it's time for us to when class starts. So you don't want to be left out. You guys end up running if you get left out. So my game plan is to provide the team with documents that you need to stick in the attorney's face to jam them up before you get to court at an affordable price. I'm going to do that at an affordable price, and that's what we're doing right now. And we're learning how to cut to the chase. And a couple of new documents that we put together. I have one package. It's called a jurisdiction challenge. It has the same document as a jurisdictional challenge, but this is called a jurisdiction challenge with a lawsuit. And that's the 1-2 punch. And that package was put together to help people who are about to get pushed off the cliff or who are already had their house stolen from them and you want to go back in court and smash some people in the face. This document helps you do that. And the biggest thing that makes this package the jurisdiction challenge with an affidavit lawsuit, the jurisdiction challenge lawsuit with the affidavit packet. Okay, come on, now work with me. Okay, what makes that different is that lawsuit and there is designed to go after the judge before the judge rules on anything. It's pretty badass. You're going to be going after the judge before the judge. And the idea here is to file your jurisdiction challenge and then wait a couple of days because you want to make sure you get a file stamped copy of the jurisdiction challenge and then file your lawsuit against the judge. And then you want to recuse the judge. Yeah, you got to watch the video. The video walks you through everything that you need to know to get this done. And then once you recuse the judge, the new judge is going to have to step up, and that's going to create a problem. When you use this package, you're going to be going after the judge for violating a violation of the Administrative Procedures Act of 1946, the Foreign Agent Registration. Yeah, you guys know the same stuff. Yeah. So if that stuff gets put on the record, then a judge is like not going to be legal. And that's going to be a problem for the judge because you're challenging the legality of the judge and it looks like you are correct. Then all of the judge's rulings are going to get called in on the carpet. Yeah. You see how that works? So it's not really about just filing your stuff, waiting for the judge to rule. Well, it's not about that at all in my program, because we don't wait for the judge to rule on stuff. We start jamming them up because the judge is going to help them. And see, this is what makes a badass program, a strategy. The judge is going to help them in the end, help the attorneys. That's what I'm talking about. The judge is going to help the attorneys. So why don't we just take the judge at the gate? Anyway, so that's a whole different program. You guys can go to my website and take a look at that package if you want to. It's pretty cool. For all those people who have been robbed already and want to get back and fight, that's what you need. And when you go to my YouTube channel, you'll also get free information that's going to help you learn how to fight today. So let's get rolling on the unlawful eviction process. The non-judicial, now the only difference between the non-judicial and the judicial eviction part of this is that you are in a judicial, you're already in court. In non-judicial, you get dragged into the eviction process in that court. So if you're in judicial foreclosure, you may be in an unlawful detainer process or whatever, but it's still in the same court. So you don't really have to worry about all that. Just follow the steps. In non-judicial, it's a little bit different because of how they drag you into court. Now, in my opinion, the non-judicial foreclosure was actually put on the records as a way for these attorneys to process a foreclosure or house when the people just packed up and left. Okay, that's because a lot of states have both, but they only use one. And a little over half the states, if I remember correct, I think a little over half the states use the non-judicial. And it's so messed up. In the non-judicial foreclosure, they only give you 30 days to come up with the full amount, plus the extra steal your hope attorney fees that they tack on the end, just to make sure that you're never going to be able to pull this off. Or if you don't pay, they'll sell your property in like 30 days. Now, a lot of people freak out and they call me all the time, worried, oh, my property's going for sale, my property's going to sell. Look, I'm going to tell you, and I tell these people sometimes, and sometimes they think I'm crazy, and that's all right. Stopping the sale is not the most important thing. The most important thing is having a strategy in place that's going to block the eviction process, because the sale can happen tomorrow. And tomorrow you can file the lawsuit or whatever you need and jam all of that up. But while you're jamming that up, they're going to start stalling if you don't have a game plan to block the eviction process. Now, at the end of the day, if you got a good game plan over here, you're going to block the eviction process. But if you stop and think about it, a lot of people worry so much about the sale of the house and running around like crazy, doing all this crazy stuff to stop the sale. And they find themselves fighting after they've been evicted because they didn't have a plan to stop the eviction process. So I tell people the most important thing is to have a plan to stop the eviction process in your strategy. Because if you don't, they're going to stall at some point in time and throw your stuff in the basket over there on the shelf right behind me. Okay, sorry. And wait it out until they get you evicted. You can't tell me that they ain't calling each other on the phone, the courts back and forth, and the attorneys, the bar members are. You know they are. And what they do is, in a non-judicial, they use a clause in the contract that they said you violated. And that's what they use to have the trustee supposedly begin the process of taking the house back. But the trustee is not involved in it. And if you will check to see who signed the documents that started the foreclosure against your property, in a judicial, it'd be the petition or complaint or whatever the hell they served you. And non-judicial, it'd be the notice of default letter or the acceleration letter, letter to cure, or whatever. You check to see who signed it. You'll find the attorney is the one that signed it. The bank didn't sign anything anywhere. The trustee is not involved. Nowhere. And And in my opinion, that's one of the biggest mistakes that most people make in fighting foreclosure. They think the bank's coming after them when the bank ain't signed nothing. The bank has not signed anything. The bank is not involved. Anybody that understands the accounting principles know that corporations do, at the end of the year, they do a charge off. And in that charge off, they're compensated twice, in addition to the money they stole from you in the first place, because your loan was actually generated with your own signature. But they do a charge off, and then they write it off their taxes, they claim it off the insurance. And then they sell this alleged debt to third-party debt collectors that are collecting it, and that's what the attorneys are doing. Now, I haven't figured out how to loop it back to how they get control of the property again for the bank to resell it. But what I do know is a lot of fraud going on, and we've been uncovering some of it. So in my opinion, the non-judicial was structured for legal purposes, but turned into ugly because of the people running the show. And then we don't know shit, but we learning shit. So so there you go with that. So the eviction court can only make a determination on immediate possession issue. They cannot make a determination on a title dispute. And this was the main change that we had to add to the non-judicial lawsuit package, because what was going on was when people were filing without having the title dispute thing going in there, people, they were filing in, the federal court was just throw it on the back on the counter up there and leave it set while they go ahead and do the thing. So we had to figure that out. So the lower court that's doing the eviction cannot make a ruling on a title dispute. So technically, if they can't rule on a title dispute, it shouldn't be in that court in the first place, because basically it is a title dispute. If so, these other fools show up with this fake paperwork, and they say, Your Honor, here's I got the new blah, blah. Yeah, so they're proving that, okay. But here's the thing: if you showed up with the same shit, the judge is going to tell you it's a title dispute and we can't hear it. Well, most people don't have the understanding. They say, well, objection, Your Honor. If you don't have it, if this court can't hear it, then we need to move it over to the court where it's supposed to be in the first place. The one where it has some constitutional rights. Okay, you might want to leave that one out, because he won't know which one. He won't know which one you're talking about if you say that. Anyway, so yeah. And then you address that issue. And the trick bag is that you can say the same thing they're saying, but it ain't going to work for you, because you ain't the one that already split up the money to steal on the property. Eviction court does not have judicial authority to make a determination on a title dispute. So to stop the eviction court, you have to have a title dispute filed on the court record. Or, yeah, there's an or, the new or that we're putting together now, or you can file your lawsuit against the judge before you even get to eviction court. Yeah, that's pretty cool. I don't know who comes up with these ideas, but it's really cool what you can come up with when you roll without limitations and without fear. So you must file your lawsuit against the eviction court judge. Yeah, that's the best thing to do. And I would add the attorney in there too. And we have all the tools that allow you to file that lawsuit against the judge and kind of take control of this stuff at the gate. Now, when I was just talking about limitations, people are, oh, is it 2.5, 3 point? You can put whatever you want on there. As a matter of fact, you can put on there that you're suing them for their corporate charter. How about that? Sue the court for the court's corporate charter, and then you get to be the judge's boss. Huh. Maybe you get to sit behind me. Okay, never mind. Sorry, I got carried away. But the point's there. You can sue the attorney that's trying to steal your house for their house. Yeah, my sister did that. and she actually served them at their house and made the attorney's wife sign too, because her name on the property. Yeah, that was the case that got terminated. Yeah, that was the case that got terminated. So, and the lawsuit that I'm using that we're filing against the judge is the one that we used in her case that got terminated. So, yeah, that's pretty cool. The new jurisdiction challenge lawsuit with affidavit. So you guys can go find it on the product page. So let me check back here and see. Hey, we got some people. Hey, Ken, Ralph, welcome. Actually, we got some people hiding out. Okay, so I got 10 people and only 5 likes. Come on now, guys. I'm going to start having brain seizures if I don't get some more likes. I'm not going to. Okay, wait. Let me take a drink of my juice. Okay, I'm feeling better, but I still need those likes. I just liked it myself, so I was running behind too. So I'm not gonna hold you guys. I'm not gonna, be too rough on you, but you need to get those likes in there. Click that thumbs up button. So the right to a trial. You have the right to a trial. And I had a lady tell me one day she was going to eviction trial. And I started laughing. And I tried to explain to her that she was not going to any trial. She said, "Oh yes." She told them she wanted a trial. Well, if you didn't file any paperwork in court ordering them to give you a trial, you really don't have a leg to stand on if you don't get the trial that you want with jurors. That's why I think everybody wants a trial, to have jurors. Well, she didn't specify and she didn't put the thing in court. So she just told them she wanted an eviction trial. So they gave her an eviction trial. And she called me back later to tell me that that I was correct. There was no jurors. There was only the judge and the attorney, just like I said. Yeah, it didn't work out too well for her. But she's still in her house. And they're supposed to move your case over to the real estate court, the one where it's supposed to be, where you have constitutional rights. Oh, no, not that one. I'm not sure where that one is. I got carried away. Sorry. But nobody demands anything. They just allow the bar members to lead them to the streets to be homeless. And I'm just saying, and I'm not picking at anybody, but that's the way it goes. Most people go into court and just follow along because they're nervous, and I get it. I was talking to a lady one day and I said, in court, when you're talking, you want to make sure that you're speaking up and talking loud. And she said, "Really? Well, why?" I said, so no one hears your knees knocking together from the fear. And she said, "Are you making fun of me?" I said, "Hell no, I'm talking about myself." Anyway, so yeah, I get myself in trouble talking too much sometimes, but I made the point. The point is, if you can't control the fear, do it scared. That's the point. That's the point. I had a lady one day. One day, I had a lady tell me. I asked her, "Are you more fearful of going to court or getting kicked out of your house and having to pack up your stuff, or find it out on the yard in front of the neighbors and all of that?" And she paused on the phone for a second, and then she said, "I'm about 50-50. Click. I hung up on her. I did. I hung up on her. I called her back, but of course, at that point, she was like, I get your point. I don't think you're ready if it's 50-50, okay? No, it can't be 50. How the hell can it be 50-50? Are you kidding me right now? But anyway, she had to figure it out. So we need to learn how to start demanding. We need to learn how to stop going into court to be the defendant. Okay. If you're in my program, you ain't going into court to be a defendant. As a matter of fact, our goal is not even to have to go into court. We want to make them not want our asses in their court because we got too much to say about stuff they don't want people to know about. That's what it boils down to. It's not about case law or any of that. It's about the facts. And here's the deal. If they can't get past the facts, they're not going to make it to any case law because we already know that they're going to get the judge to help them. And we got a plan for that. And each one of the packages that I sell, there is a provision to sue the judge. And I will bet that not very many of you that have the packages know what the name of that lawsuit is that you have to sue the judge with, or what is on there that you're suing the judge for. Any ideas? Let me help you. Violation of Administrative Procedures Act of 1946. I keep saying the same. Okay, sorry. But you get it. That's already in the package. Now, what I'm using now is a little beefed up and a little more, but you know, how much beef do you have if they can't respond to it? Well, I still like to have some beef. So, you know, the commercial from the 70s, where's the beef? Okay, never mind. I got the beef. Now, when you make a big stink about them not moving your case, then you can shut the case down. When you make a big stink about them not moving your case out of the eviction court over to the other court because that court's lack of jurisdiction, they don't want to hear it. They're going to tell you to shut up and go sit down so they can make you agree to the payments. Yeah. These people that have these Zoom hearings with these judges and stuff, all they want to do, they want to talk about the payments. And I don't understand how anybody can fall for the payments, because if they was going to allow you to make the payments, they wouldn't have paid this attorney to come over here and kick your ass and take your stuff. I mean, you know. But some folks, when they hear that payment thing, they just think, oh, great, man, it's over. They're going to help me. Yeah, and you know where that goes. That's not what just happened. What just happened was you just agreed that you owed the money, okay? When you didn't object to the payments and went along with it, you let the judge know that you're in agreement to making the, especially when you step up, you think it's all great and they're going to let everything go back the way it was. No. What you just did was let the judge know that you owed the money. All the stuff that you filed in court is worthless because you just agreed to make the payments. Think about it. You did not object to making the payments. You told the judge there was a real loan and that you owed the money. Totally in contradicting what's in the paperwork that you filed in court. This is why when you go to court, the only thing you should be discussing, or on a hearing, or even talk to them fools on the phone, or talk to the clerk, the only thing that you should be discussing is the stuff in the jurisdiction challenge or the jurisdictional challenge, the 6 missing things, okay? And the fact that the statute's not a valid law because it doesn't have the 3 elements necessary according to the state constitution to make it a valid law. Those are the things that you should be like, I would be telling the clerk, look, you can dismiss this yourself because you can see right here, why waste the judge's time when these attorneys are full of crap? Okay, well, now after all of that, you think they're going to let you make payments. You go home thinking everything's all great. They're going to accept payments and everything's cool, only to find out that they showed up at your house with the popo in about 10 days to kick you off of the property. And at that point, even if you had the paperwork to file, what would happen is they would throw your stuff on the desk over there until they're done cleaning you out of the house, because they already took the money and split up the money. That's my take on it. So the court's fraud. When the question of title is intertwined with the issue of possession, then possession may not be adjudicated without first determining the title. I mean, it's simple. It's simple, guys. Now, what you do is you use the documents to get your title dispute filed in the federal court, and then you use those documents to control the lower court. In the lawsuit package, you have the document to remove the process from the eviction court over to federal court and connect it with your federal court case. And most everybody who done this, it worked out for them to connect it and stop the state court process, but not everybody. And one person that didn't work out for called me before he got to this point to ask me questions about the documents, because he said that his attorney friends told him that my documents were crap and blah, 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 you know. Your attorney friends. Yeah, that was kind of a problem. I'm like, dude, I don't have time to waste on your attorney friends, okay? You should probably have them help you and ask them the questions that you need to ask them, because they seem to be the ones that you're listening to. And it's sad because he ended up getting jammed up because he didn't follow the process. Some people have a hard time jumping on the judge's butt. And if you don't, they're just going to mow you down, because you already know how this system is structured. Their system is structured for the arguing. And then once the arguing's over, the judge gets to help them. And then when the judge gets done violating you, they tell you to appeal it. Well, you don't have to appeal it. You can sue their ass. Why would you want to appeal it? Yeah. Okay, go appeal it and wait while your time's running out to sue them. And then when they're going to dismiss it from the appeal, because in most cases, there's no title dispute on the record that would interfere with the judge's BS going on in eviction court. So you don't have nothing to appeal on. And most people don't even object. They just let the judge's ruling be it. Oh, I did not realize that no matter what the court said or what the judge said, I should be objecting to open the door for when I want to kick them in the face later. Most people don't. Oh, the judge ruled and that's it. No, you get the last say if you want it. That's what we learn around here. So creating that title dispute is the key. And then using everything, when you start filing this stuff, then to remove the case over there. Well, I'm removing it because it's immediate possession issue, and the title dispute trumps immediate possession. So that court don't have jurisdiction to hear it. People don't understand the paperwork enough to tell the clerk this, because the clerk's looking at your stuff thinking, I've never seen this. No, they haven't. And they'd like to put it in the trash can too. So keep your eye on them. So when you challenge the lower courts, the lower eviction court, they're supposed to send you over to the state court where it should have been in the first place. But they often don't, because people don't know. And people don't know that you actually have to get it on the record that you're doing this. You can't just say, hey, like this lady said, I want to have my eviction trial. Okay, come on in. We're open right now. Yeah, but she didn't understand what she should have got on the court record, demanding to have a trial by a jury. There is eviction trial, and most of the eviction trials are done with the eviction trial judge and the eviction trial attorney and the defendant. Yep, there you go. The defendant getting punched in the face. So you can't be that person if you're going to be in our group. So remove the immediate possession issue from the eviction court and connect it with the title dispute filed in federal court. And I would tell them, hey, when the federal judge is done making a determination on the title dispute, there's not going to be an issue because I own it, and not the attorney who doesn't have any consideration in anything. And there's no lender here. There's no witness. Without a witness, it's a wrap. And you want to object every single time the attorney opens his mouth. You're objecting because it's hearsay. There's no witness. You get the case shut down if you be an asshole. I mean, if you, yeah, you know what I'm saying. So, file a motion in federal court requesting a judge to make the immediate possession issue moot after you connect it. And then you can take those documents down to the lower court and shove them in their face. I mean, and file them in your case. Yeah. And have some fun with it. You know, and I had one lady tell them, and when she took her stuff down there, she told them, could you guys please send my court record over to the federal court so I can have a record of the nonsense that the judge has been doing? Because basically what she did was use the court record as evidence in her federal lawsuit against the attorney for foreclosure and the judge for helping the attorney with the foreclosure. Yeah. Created nice little evidence. You didn't even have to ask them for anything. You're ready to go to trial by jury. Okay. Trial by jury. Remember, trial by jury. Jury trial. So we're learning how to cut to the chase. So we'll also learn how to stop the court in non-conventional ways, like filing the change of venue motion. The change of venue motion was really cool. Any party can move for a change of venue in the interest of justice. And you're moving for a change of venue if you're using my document because number one, the attorney is considered a foreign agent. And the fact that the attorney filed a notice of appearance verifies to the court that the attorney and everybody else who understands this, that the attorney is a foreign agent. And a foreign agent cannot file a dispute in state court. You cannot sue another person in another state in state court. You have to file in federal court. These are some little loophole things that I figured out because I'm nutty. Okay. I'm just gonna say it. Yeah. So the attorney is a foreign agent, and a foreign agent must file in federal court. State court does not have jurisdiction to hear a claim filed by a foreign agent from another country against a state citizen. So that's number one reason. And number two reason is because they're in violation of the Administrative Procedures Act of 1946. And in this one, they're in violation of the Foreign Agent Registration Act of 1938. So those are a whole bunch of real good reasons why do you want to move that case from state court over to federal court. Now, here's something that's kind of cool. If you're using my stuff, I use federal case law and everything. Even if I structure something to be filed in state court, it has federal case law in it because, and I have the case law in the document to verify this, you can file higher court and lower court. It's no difference than filing Supreme Court case law in state or federal, okay? So if you go in my documents and you move it from state to federal, you're good because everything in the documents are federal court already anyway. And they're not so good because all of their stuff is state. You can't file state case law in higher court. Don't go that way. So by filing this change of venue, you force them to, refile their lawsuit. I mean, once I file the change of venue, I would probably follow up with a motion to dismiss because they have state court case in their federal case. Yeah, I love it. The shit I come up with. I come up with some stuff, don't I? Okay. Hey, Phil, Heath Lee, Calvin. Yeah, I do. I come up with some pretty good stuff, don't I? Yeah, Ken said limelight. Yeah, so Ken, yeah, we've got some things going on in California. There's going to be a few more people being able to do some punching in the face in California. Hey, Troy Taylor. Yeah, Zarel, what's up? Come on, guys, give me some thumbs up. I got 14 watching. I only got 8. I'm keeping an eye on that. Who knows? I might have a sale at the end of the day, but if I don't get a thumbs up, I'll be grumpy. So I'll make everybody get online and run. That's how we do it. Okay. So this change of venue motion was structured for the folks who have um, nothing to use and to defend their property and are struggling financially. And who knows? I mean, if you know and been doing this for a while or been following my stuff, this document would be great to have to just kind of get everything thrown in the toilet. Because they're not going to be able to. I don't know. I made this to use against in my sister's case, but while I was making it and going over the docket sheet, I figured out that they had terminated the case 4 weeks earlier. So they terminated the case when we filed the lawsuit that we filed that's in this package. So, I mean, in the last package that I talked about. So this package is just one to give you time to get control of this so that hopefully you can stay in your house. That's our goal here, is to help you learn what you need to do to stay in your house. And sometimes people think some of the things that we do is a little nutty, but in the end, they understand. And the reason they think they're nutty because they don't understand all the stuff that I know, because I've been working with a lot of people from across the whole United States of America in our private Facebook page. So I have people that call me or contact me and they start bouncing stuff off of my head and like, no, look, we don't do what you were doing already. We do something totally different. And we don't connect any of that because that wasn't working or you wouldn't need me. So why would you want to connect it to us? Okay, so you see how that goes. A lot of people kind of freak out, and I have to explain to them that if they understood everything that I'm saying or doing right off the bat, they wouldn't need me. And the value is there that I know I've learned this stuff from helping people and doing all the things that I've done and gone through over the last really long period of time. But people should understand that you're not going to be able to understand everything that I'm saying. But I have great reviews, and I think I have the best reviews of any legal business that I've seen, and I challenge them. And I would also challenge any bar member that thinks that what I'm doing is not right. They are welcome to let me know if they want to be on the show, and I'll set it up. Yeah, I'll set it up. And then we could just talk. As long as we're respectful, we can talk, and you can let me know what you think, and I'll certainly let you know what I think. Well, in most cases, you already know what I think. Oh, wait, I already know what you think too. So, but it'd be good to hear it. So if there's anybody out there like to do a challenge with the coach, let me know. So the state court lacks jurisdiction. The attorney is a foreign agent. It's noted on appearance on the entry of appearance, and that's how you jam the court up with that. That entry of appearance they have to file because they're a foreign agent. Now, if they're a foreign agent, they need to be getting their butt on over to federal court and start playing around. They're playing around down here because they don't have to file the stuff that they need to file in federal court before they can move forward in federal court. Oh, yeah. So they get to screw around in state court. Hello. File your title dispute in federal court. And when you use the jurisdiction challenge with an affidavit, you might as well start getting your program and what the program is going to be, because they're not going to be able to respond by counter affidavit because they're lying. And we already know that. So they're not going to be able to respond by counter affidavit. So they're lying. And judge is going to have to help them. We already know that. So these things should be ready to go when they get done playing around, or you can just get the jurisdiction challenge with lawsuit with affidavits and shut them down at the gate. I can't wait to see how that works out for people. So the motion for a change of venue can be used to move the case, to take control of the case, to, and you see how that works. And then if the judge denies you, then you can sue the judge for helping them, because that's what you have to do. You have to be able to have a strategy that's going to jam up the judge when the judge tries to help them. So I've had people who file this lawsuit in state court, and then they use this strategy to move it to federal court after you spank the judge with helping the attorneys. Because think about it, when you spank the first judge with helping the attorneys, then it needs to be moved to federal court, because all the other judges will have a conflict of interest. So you can move it to federal court and avoid paying the filing fees. I did that myself with three $10 seatbelt tickets. Yeah, I'm a pain in that. Yeah, I'm a pain in somebody. Yeah, I was a pain in their ass. So this challenge of change of venue motion is actually structured for South Carolina, but it's federal. You can use it in any state. People call me all the time and they get themselves wrapped up in the state crap. The state crap. Here's the thing. The rules that you're supposed to follow in a state court are what? The federal rules of civil procedure. The rules you're supposed to follow in federal court are the federal rules of civil procedure. So where the hell did they come up with the local rules? Yeah, they just made that shit up. I mean, they did. So the rules are supposed to be followed, the rules for a federal court in the first place, and that's why federal court case law, But people get caught up in that shit so much. And when you follow the state, you see where it leads you. Oh, wait. The state statutes are not valid laws because they don't contain the necessary elements to be considered a valid law. They don't have enacting clauses. They don't have a title. They don't have a body. So thank you very much. It's a wrap. Okay, sorry. Remember, they have the burden of proof, not you. Everything we do is about challenging the court's jurisdiction or lack thereof. So the motion to change the venue is posted. It's posted on our. Actually, I posted in our Facebook group, and I'll leave a post. I'm trying to think if it's on the new website. I'm not sure if I have it on the new website or not, but I still have it on the Sam Card page. So I'll post that in the feed here pretty quick. Now, you guys should also make sure you fill out your affidavit of state citizenship, or at some point complete that process with your passport, because that has a lot of value when the police are harassing you down the road. And also it adds value to what you're doing in court, because when you can verify that you're a state citizen of the republic state you're born in, then that they don't have the court statutory jurisdiction do not apply to you without an injured party. So third-party debt collectors and all the stuff like that are all done. You just send them a cease and desist letter and a copy of your or verifying your state citizenship, and that should be the end of it. And if not, then you can sue them for that. But in most cases, it usually is. Hey, Lynn. Ken McGuire. Thanks, Ken. So if you guys haven't been to the new website, you should check it out. Let me see if I can find that. that change of venue. Yep, there it is. Now, if you're struggling and this change of venue motion is so powerful, you can turn it into whatever you need. Okay. You could turn it into a motion to dismiss. You could I would turn it into a summary judgment, jamming back in their face. Because if you turn that into a summary judgment, that would be fire. Now, I'm going to also post in the group a link to the non-judicial and the judicial foreclosure packages on my new website. Now, these are still on sale. So I started a coronavirus sale, a pandemic sale, and they're still on sale. So, and if everybody starts buying them, I will be able to leave them at this price. But if the price changes, it's because, well, sometimes my investors get grumpy and they make me do stuff. Yeah, I'm going to post one more thing in here. And I also want to give you guys a link to the property tax package. Oh, no, that's not the one I want to give you a link to. I'm just confusing you. I want to give you guys a link to the package that we were talking about. The jurisdiction challenge with an affidavit. The jurisdiction challenge lawsuit with an affidavit. Yeah, it's pretty powerful. Okay, here we go. Okay, guys, that's about all I have for tonight. I appreciate you guys sharing the privilege of sharing your time. So I'm running kind of late today, but I hope I brought a little value to the table. And thank you for the thumbs up. Great. So this is what I'm going to do. I got 14 watching and 12 thumbs up. Would be nice to have the other two, but that's all right. Some people stepped up. And I'm going to tell you what I'm going to do here. I'm crazy. My investors are out of town and they left me in charge. So here we go. Put my money where my mouth's at, my mouth where my money's at. Here is my Lemonade property lawsuit package at the best deal that I ever had it at. Now, I gave some of the people in a meeting on Tuesday this deal, and I want to give you guys opportunity for the deal. Yes, Yazrel, the link for the divorce package is on my website. So I'm trying to do a special deal here, man. Okay, sorry. Yeah, that's on the website. Go to the website. You can see it on there. Hey, Jeremy and Mendinos. So anyway, the deal. Here's the deal. I'm giving you guys a deal, and I'm going to leave this deal on here until Monday night. I give people one working day till Monday night. And here's the deal. The deal is cheap. Cheap. I can't even tell you how cheap it is. I'm just going to post it, and y'all need to go and check it out. This is a deal on the eliminated property tax lawsuit package. And Ken, I hope people in California, a lot of people in California get it, because I love giving them attorneys in California a bunch of crap. Well, excuse me, I'm not giving them crap. I'm hiding out over here. Oh, my finger is having trouble hitting the thing. There. $200. Tell me that ain't badass? $200. Limited property tax lawsuit package. $200 until Monday. And I don't want to have nobody calling me complaining about anything if you missed out. Okay, because the $200, when people get back, and if I don't sell a bunch of these, they're going to be grumpy. And one other thing, please don't drive to my house because I'm not answering your calls fast enough or whatever. I don't do business from my house. Don't drive to my house. All that's going to do is piss me off. And when that happens, you're not going to be here. Okay. I have this set up to where I don't meet people. And the reason I don't meet people is because it's easier for them to say, I'm practicing law without a license and all of that crap if I'm doing certain things. If I'm meeting people and I'm looking at their paperwork and having them send me their court documents and telling them what I think about it, and I ain't having none of that. So if anybody does anything that fit into that category, you're going to get lumped in with the people over there trying to kick my ass, and I'm going to have to kick you to the curb because I don't even play. Okay. I got a few rules. If you're not going to follow the rules that protect me and allow me to help everybody, because I can't help you if they're dragging me off. Now, I'm not sitting here worried about that because they already tried, but I'm not going to be stupid, and I'm not going to give them a free shot at me. And if people can't follow the rules and the program to protect not only me, but you too, because you know what they do, they're going to say, hey, you help us and do whatever, and we're going to give you a deal. Yep. And then when I get back out, yeah, I don't want to have to do that to anybody, okay? Because you know how I roll. And they harass me, then they're going, whoever's helping them, that's the way we're learning here. If the judge helps them, whoever helps them, they get added into the program. So follow my rules, and none of us have to worry about that. If you don't follow the rules, don't send me your documents unless I ask for them, and probably not. And don't come to my house to tell me about anything, okay? Because that ain't the way I roll. Yeah, had that happen today. Yeah, I wanted to sick my dog on him, but I was trying to be nice about it, as nice as I could. So you guys remember that. The rules are there to protect us and to keep this rolling so that we don't have any problems in the program. Now, if they want to come and harass us, they're going to have to bring a lunch. And they might need a couple of lunches. And they're going to need more than one attorney if they want to come. I'm just saying, we need to follow the rules. And if you disrespect me like that, you're not going to be in the group or on my list anywhere, because I don't have time for drama. And I tell people this all the time. I do not have time for drama. And I don't care about all of this stuff. Here's the thing with me. Okay, I don't get emotionally wrapped up into all of this, or I wouldn't be able to help anybody. My brain would explode. So Jeremy, they don't want to get sent to the bench. Well, the last person I mentioned the bench things on, Jeremy, got mad, and so I don't talk about the bench anymore. I just tell people I don't have a bench. So if you get sent toward the bench, it's on out of the adios. Hasta luego. Okay, so yeah, that's how that goes. I don't have a bench. So you're either in the game or you're in the freaking way. And that's what my coach used to. That's how I learned. You're either in the game, you can be standing over there, or you can sitting over there, but you are in the game. Yeah, okay. Anyway, so I'm gonna let you guys go. I will see you guys hopefully on Tuesday night, and I want to talk a little more about how to control the attorneys in the court. We need to talk about that a little bit. We have a few things come up, so that was actually what I wanted to talk about tonight too, but I didn't have enough time. So we'll see you guys next week. Good night, everybody. Thank you for coming and listening to me yucky, yucky, yucky. Oh, take advantage of that deal. Okay, you guys can go in together and share the stinking thing. You're not going to get a deal like this again. I need people to get that $200 deal so I don't get in trouble when my people get back. Good night, everybody.